Last matter on the calendar is 18-2-189734, Brian Cortland versus Lewis County. This matter is before the court today for a public records scheduling conference. I will indicate that this was not on my calendar today, and my clerk came in 5 minutes before the hearing and indicated that it should have been on the calendar. I had time to look at the case and saw that Judge Dixon was originally assigned to this case, that an affidavit was filed against him. It was then reassigned to myself, and that in that notice of assignment that was filed on April 26, 2018, that in fact that scheduled today's hearing date. And I'm saying this because I haven't had enough. Normally I read the complaint so I can understand the issues that are before the court. I did not have an opportunity to do that for the purposes of today's hearing, but that doesn't mean we can't go forward. It just means that I won't have as much information as I normally have. Mr. Cortland is represented today by Mr. Thomas, and Mr. Eisenberg is present on behalf of Lewis County. When I called through the calendar this morning, or before I called through the calendar, Mr. Thomas came forward and indicated that he believed that perhaps it would be an ex parte matter. I indicated I would call it in the regular course because it was on the calendar, and that's how I handle things if something's actually on my calendar. And Mr. Eisenberg indicated also during that initial calendar call that he did not realize that this case was set for today. And so I want to hear from Mr. Eisenberg about the issue of the scheduling, because there was an administrative setting of this hearing when it was reassigned to myself, and that was filed on April 26th. Mr. Eisenberg.
Thank you, Your Honor. I don't believe I am misspeaking. I believe that Mr. Thomas would agree that that Lewis County did not get notice of the filing of this lawsuit or its scheduling on any day, nor any notice of scheduling order or hearing being set. I believe that that is the case because Lewis County had not served Mr. Thomas with an answer or notice of appearance in this matter. It has been, I am guessing, served with this lawsuit because we have been served with lawsuits that were not filed. But I don't know which lawsuit it is because I didn't get any notice about today's hearing. I believe that that the premise under which Mr. Thomas is operating is that when a party has not appeared, they are not entitled to notice of default. But in this circumstance, Lewis County has appeared in all pending litigation with Mr. Cortland, Mr. Green, and Mr. Hupy, because just as, if you recall, you've seen a stipulation with Mr. Hupy that covered all pending litigation for global settlement. A similar stipulation exists for both Mr. Cortland and for Mr. Green. And so I believe that under the rules regarding default, Lewis County was entitled to notice that this lawsuit was filed and notice of any potential default, but I didn't get any, so I don't actually know what's on today. Thank you.
All right, thank you. Mr. Thomas.
Lewis County never formally defended this action. There was no notice of appearance. There was no demand in order to file this lawsuit after it was served upon Lewis County on January 9th. We did enter into a state of litigation from, I think, January 26th until March 1st, not March 23rd, but March 1st. And that ended, and I forget which date, I think it was around the beginning of April that we actually did file this lawsuit. And so more than 20 days had passed, and it was, the plaintiffs believed that Lewis County didn't have any formal intention in order to defend this lawsuit. Case law is very clear that moving ahead ex parte or default is appropriate, as this court mentioned in the earlier case, if there is not any formal, if the opposing party does not formally defend the lawsuit. Supreme Court actually talks about settlement conferences. Settlement conferences outside of court are not enough. It needs to apprise the court for due process to make a record that it actually intends to appear somehow. Even a motion to dismiss filing could be construed as a notice of appearance, but there was nothing filed. There was nothing even alleged to be served upon plaintiff as a notice of appearance or a demand to file the case or anything else. So there was no way that plaintiff knew that Lewis County intended to defend this case. Plaintiffs aren't a mind reader.
All right. So a couple of things. I indicated that this was just Cortland versus Lewis County, but it's Cortland, Green, and Hupy versus Lewis County. There is a declaration of service that indicates that David Dunham caused the plaintiff's original complaint, Ray transcripts, and plaintiff's summons delivered in person to the Lewis County Auditor's Office. It doesn't say what day that happened, but the declaration of service is signed January 9, 2018. So that is the lawsuit that is before the court today. There is, or perhaps, I don't know, perhaps Mr. Thomas has a motion for default that he was going to hand forward today. I'm not certain. But even if someone were to hand forward a motion for default at a hearing like this and the other side has appeared, the court's not going to grant default because the other party has appeared. And Mr. Eisenberg has appeared on behalf of Lewis County today at this hearing and has indicated he doesn't believe he has service. I'm not ruling on that issue today. The issue is whether or not I would somehow do a default if a motion for default was handed forward. I would not, because the other side is here today and has appeared. Certainly, Lewis County will now have an opportunity to file a response, raise any objections, respond, whatever they're going to do, but in a short time frame, because we need to have a PRA scheduling conference. And I'll just continue this hearing 1 week, since I know that Mr. Thomas is coming next week already, and I'll set the PRA scheduling conference on that date. And certainly, if Lewis County hasn't responded by that time, the plaintiffs in this matter would have an ability to file a motion for default, and the court could address that issue again next week if the defendants did not timely respond. They have appeared today, and that's why I would not grant default.
Your Honor, defendants here, I don't know why we can't have the LCR 16 PRA status conference today. We're both here.
Well, and you'll both be here next week, and Mr. Eisenberg indicated he didn't even know what case this was. And again, I'm not saying that it wasn't served, that they didn't have notice. I'm not dealing with any of those issues today. It's whether or not I would go forward with a PRA scheduling conference when I even didn't have a chance to look at the file, which I normally do before. And that's no one's fault. That somehow was an error in the clerk's office by them not scheduling it before me today. But when 2 of the 3 of us haven't looked at any of the records involved, I don't think you can have a meaningful scheduling conference. And so I'm just going to continue it 1 week, and that way we can have a meaningful scheduling conference and get an appropriate hearing date. And I'm asking my clerk to simply set that over, even though it wasn't on my calendar today, but to set it over 1 week, and that way we can have the scheduling conference and I can enter an order after the scheduling conference at that time. Thank you.
Thank you.